police officers ordinance. Should we offer,
from council first and then public hearing, or the other way around? Public hearing first?
Why don't we go ahead and open the public hearing first and get feedback on it before council speaks?
I'll sit here. I'm sorry. I got toddlers. To concur, I was here at first reading, obviously. We spoke about it at some length. I'm upset that it's here for second reading unmodified. All the things that came out just today or the day before, a lot of it's new to me. It's not much of an impact. I don't feel. I really want to focus on the impact of the police department and how it will affect those officers that are currently within that department. That pension board is its own unit that some members of this council serve upon. I would assume they have counsel that they would listen to. I know that counsel because he is my counsel also. I've known him for over 20 years. Recently went to the Supreme Court with that counsel. Klausner, Coffin, Jensen, Levinson, probably one of the best pension attorneys in the state of Florida. We recently overturned the financial urgency lawsuit with that law firm, a $250 million judgment against the city that was recently settled, the city of Miami. I would not take their opinions lightly. I think their opinions are sound. It's my understanding that their opinion on this ordinance was to not enact it, and that was the statement given to the pension board. I would heed that. I would heed that recommendation. If the union attorneys aren't saying they don't want you to do it, and the pension board attorneys saying you don't want to do it, you should probably ask, why are we doing it? I don't believe it's with all due respect to the village manager, I don't think that that's the reason. It's not really relevant to me anyways, because I think as a charter position you can stay on as a 401A. It's very normal in Florida to stay beyond. Chief of police also is one of those positions under Chapter 185 where you're allowed to stay beyond. My chief currently is staying beyond on a 401A. He's done his entire drop. He has a 7-year drop. He's exhausted it. He still can accrue those benefits. That's allowed. It's beyond that. It's the problem. So what I would ask you to do is look into that pension board and ask them what their opinion is, what that pension attorney's opinion is, but then ask the officers. What do you think the impact is going to be on the police department? What is the reason for this? Is it for retention of upper management? Is it for retention of the police officers we currently have? What would be the advantage of it? Are we going to be able to hire a police officer that doesn't participate in the pension plan? I'm telling you, you can't do it. You can call them something else. You can call them a school safety officer. You can call them a crossing guard. If they got a badge and a gun and arrest power, they're a cop. They must participate in the pension plan. This is how these things work. And if you don't, you will jeopardize your ability to have one. You will jeopardize your tax-exempt status. You'll jeopardize your ability to be able to maintain your pension system. So ask them. But you guys know a lot of their police officers. Ask them what they think. Ask them why they're doing it. You know, how long is our department going to consist of a command staff that looks like me, middle-aged white guy? Never had anything but that. You know, your department should be a reflection of the community you serve. The command staff in that department should be a reflection of the community you serve. And sometimes that's difficult for us to come to terms with. If this is some way to circumvent that, I don't know. I don't know. But I think the cops here are great. I think they are diverse. I think they want to move their way up. I think you have a lot of good police officers and supervisors that can move their way up into this department and become command staff and be successful. I think you should consider it.
Great. Thank you very much.
Good time.
Is there more public comment on this item?
Crystal, I have a question of why this was undertaken to begin with, given the fact it only applied to several officers, and the amount of money that was spent, and the amount of time that was taken for all of this. You know, this wasn't a process where, gee, our whole police department is affected by this. We've got 7, 10 people we need to change our pension plan for. It was essentially for 1 or 2 individuals. And for the purpose of having these one or two individuals, this village has spent a lot of money and a lot of time, and it said, you've got lawyers who are also being paid for, who said, don't do it. So the big question is not the end of the process. It's like, why was there a beginning to this process to begin with? And what does that say about going forward and about what that says about the police department? Because it's the same management then that it is today, right? So I just think that that's something that might get lost in the process.
Further public comment on the item? Okay. All right, so we're going to close the public hearing on the item and call council up to talk about the item, and maybe you can respond to some of these concerns in the process.
Yeah, Mr. Mayor, I think it'd be best if we hear from our council as to the reasons why this ordinance is before us tonight. Because like the union and the pension board, we have an attorney as well, and he's here tonight. And I think it would be best to hear the substantive reasons, and again, rather than engage in personal attacks for no reason.
I'm Leonard Carson from the law firm of Carson and Atkins. I'm a special labor counsel to Miami Shores Village. Several years ago, the village officials began interpreting their pension plans to permit the payment of retirement benefits to individuals who had retired after their normal retirement date, but then were rehired under a contract of employment. And both the village and those employees had a good faith belief that what they were doing was permitted by the plan. And various members continued to receive their normal retirement benefits from the plan, their funds from the TROP plan, and it was a normal practice among many municipalities in Florida, so we were not alone in this. After several months of investigating the circumstances, the village was informed that because the plans did not include a provision for in-service distribution, the practice violated the terms of the plans and therefore constituted a qualification failure with the Internal Revenue Code. And what that means is what was a qualified pension plan would no longer be qualified, and the plan was in jeopardy, as well as the individuals. The problem was that benefits that had been paid to retirees in the absence of an in-service distribution provision constituted an overpayment as far as the IRS was concerned, because the retiree or the beneficiary should not have received any distributions while working for the village. So that was the problem. The IRS had several potential corrections. One of them was to ask the retirees to return the overpayment to the plan. You're talking about retired people who spent years of service, are now living on a pension, you're asking them to return the money because there's been a mistake made. Mutually relied upon, something that was common in practice in the state of Florida. The other thing was to reduce future pension payments until the plan recoups the overpayment. Once again, you're in the same situation. You're taking what is a small pension to begin with and reducing it in order so that you can recover the money. And the third plan was the one that we finally agreed upon, and that was to amend the ordinance to retroactively permit in-service distributions. It avoided any economic hardship on affected members by doing so. Now, what this means is...
And let me interrupt just for 1 second, because I think this is an important point of clarification. How many employees were affected, and was it, who were they? Were they police officers? Were they members of the staff?
Police officers and general employees. I don't know the exact number, but there were several of them. There's more than two.
Okay.
What it amounted to was, had the plan included in-service distribution provision, everything would have been okay. So what the IRS said was, go back, amend your plan to say that what you did was valid as of the time you did it, make it retroactive. So the missing language was supplanted, and the IRS was happy with that. We have a deadline for compliance. It's April 14th of 2019. But what happened was the IRS resolved this under a plan they call the Voluntary Correction Plan, which requires an appropriate amendment to your ordinance, documentation, discussions with the IRS, and their approval of it. The language which is in the ordinance is exactly the language that the IRS asked for. That's what was subject to approval. There's There was some discussion about whether the language was inaccurate. I understand there was a clerical error due to transposition or something. The ordinance language is correct. And the IRS, in one letter dated October 12, 2018, said, please revise your section as follows, and recited the exact language of the ordinance. That was for the police plan. For the general employees, there was another letter dated October 15, 2018, reciting the exact language which is in our ordinance, saying this is the language that will be approved. If you adopt this language, we'll be okay. Now, qualification means the plan is in jeopardy. It's not just a matter of the individual employees having to pay back money, but the tax-exempt status of the program is gone. And so this is a big deal. Now, when we had communicated with various lawyers about the plan, pension lawyers, everybody wanted to shy away from it. Oh no, it's terrible. The plan's going to go to kaput. There's nothing can be done about it. Well, there was a lawyer who we retained, who had been retained by us before, who had experience in doing this and had in fact brought about a successful resolution. That's why we retained him, because he had the experience, he knew how to do it, he had a solution, and he wasn't afraid to take it on. Now, the problem began in 2012 for general employees, in 1994 for police employees. So there were many people during that period of time that were subject to this provision. That's why the retroactive dates are different, because the problem started at a different date. Once the ordinances were presented and were talked about, and the FOP found out about it, they initially claimed that we had some negotiating to do because this had some negotiable impact. I met with them on December 4th in a bargaining session to determine whether there was any impact bargaining which was necessary. Now, under impact bargaining, it's the obligation of the union to demonstrate a direct and substantial impact upon their terms and conditions of employment. They came up with a lot of ideas, a lot of issues, none of them related to the problem we were trying to solve. The problem we were trying to solve is to fix the qualification, make sure the plan retains its qualification, and that those employees who had gotten this money properly, it was their money that they had earned under the pension plan, they would not have difficulties with it. The other issue they raised was Chapter 185. They said that you could not have participation in the everybody had to participate in the plan. I asked them, and I asked another pension lawyer to show me where in Chapter 185 was the language that specifically said everybody had to participate in the plan. No one has come up with that language. Usually there are rules adopted by an agency to further their understanding of a statute. In 1974, the legislature adopted the Administrative Procedure Act. It was a revised program. The reason for it was that we had pocket government. Agencies would determine what to do, nobody knew where, knew how, knew why, and so they developed the new Administrative Procedure Act. Administrative agencies cannot simply interpret a statute without going through a rulemaking process. There are several ways in which they can accomplish this. If they have a policy which is of general applicability, which means that it applies across the board to everyone, the only way that they can adopt that as policy is to go through a rulemaking process where rules are drafted, published, there's an opportunity for public input, and there's an opportunity for a hearing before an administrative law judge to determine whether or not there's substantial legal justification by the legislature, not the agency, to adopt those provisions. If they do something without adopting it, it's non-rule policy, it's subject to challenge. The other way to do it is to ask for a declaratory statement. And there's no declaratory statement on this point that I'm aware of. So you don't simply, like in the old days, ask an agency, what do you think about this, and get an answer. There has to be an opportunity, a window of opportunity for anybody who is affected by what the administrative agency does to challenge it in some way before an administrative law judge. I'm telling you this because there's been so much fuss over 185, and I'm telling you that it doesn't really have an applicability to what we're doing today. The issue is, can we satisfy the Internal Revenue Service that our plan deserves to retain its qualification? If we do everything the IRS asks us to do, and we do it by the deadline date, we'll be home free. Now, I suspect that one reason why there's a lot of confusion over this is because there's a belief that we're not trying to solve the old problem, we're trying to generate some new activity. There is nobody in the officer or sergeant rank under a contract at this present time. The village has no present intentions to do that again. The only people we would intend to have a contract with would be, under these circumstances, would be the police chief when he retires. When I met with the FOP in our negotiations on December 4th, they said they had no problem, no concerns with the chief. We do have a concern that there's one individual who's under contract at the present time. It's the lieutenant. Lieutenant is not in the bargaining unit. And so the FOP has no right to negotiate over anything dealing with the lieutenant. He's not an officer or a police sergeant, so they're out of that. Their suggestion was that he ought to be part of the plan. Well, the Miami Shores Village Police Pension Plan in Section 18-64, reads as follows. This describes who belongs in the plan. Employee means any police officer of the Miami Shores Police Department employed on a full-time, permanent basis. Employees serving on a part-time basis, and those individuals under contract for a definite period of time, or for the performance of a particular or specific purpose with the village, shall be ineligible to participate in the plan. Now, this is a plan which had been subject to approval by the Division of Retirement. Otherwise, we would not be getting our state money if it was not valid. And the lieutenant's agreement provides that he's an at-will employee without a property interest in continued employment, so he has no chance of being considered to have a community of interest with the FOP officers. His increases in annual compensation are based on the general employees program, and except to the extent that he's currently receiving retirement benefits for the plan, he will not otherwise participate in the police pension plan or any other plan of the Miami Shores Village. But most critically, he's on a 365-day contract. This individual couldn't be part of our plan if we wanted him to, unless we amended the ordinance. There's been no suggestion to amend that provision of the ordinance to bring him in, but it's been used as a red herring to say there's something wrong with this ordinance. Now let me address, there was a letter sent out just recently by the FOP, by Mr. Coop. He raised some issues, and I want to address those for you.
I like that. I'd actually, if we can walk through those issues one by one, very methodically, I want this to be completely transparent. I want all these things to be discussed.
All right, let's take first the issue of the village manager. I might tell you this, that in a public sector entity, disqualification of your plan has virtually no effect upon the village. It affects the officers who are in the plan. If you are a private sector employer where you're taking deductions for contributions to the plan, then the employer would have a heck of a problem. We don't. It's the employees. So what we're trying to do is rectify this for the employees and validate the plan. Now let's talk about Mr. Benton. When Mr. Benton reached the normal retirement age, he opted to go into the drop plan, which is provided for by our ordinances. Everybody does it. It's lawful. It's authorized. The drop plan keeps you in for 5 years. At the expiration of his 5 years, he continued on with his employment. He did not terminate employment. He did not retire, as these officers were talking about, and the general employees were talking about. He continued on. He gave up for 4 years his pension. His drop plan was frozen. He earns nothing on that. It was locked in as of that point in time. So he has lost several hundreds of thousands of dollars of money that was his. He earned it under the pension program, but gave it up. This ordinance has absolutely nothing to do with Mr. Benton. If you look at the ordinance, he's under the general employees plan, and it refers to a retired member who is terminated in employment. Mr. Benton has not terminated employment. All the other individuals we're talking about terminated their employment and then were rehired. He continued on, and because he was told that he had reached the expiration of his 5 years of drop, he gave up his pension from that point forward. So the pension plan is actually benefited. They've gotten his money, which was his, earned by him, and he didn't get to use it. The pension plan has the money. And then it goes on to say...
Can you clarify that point just for 1 second? I'm sorry, but that money is accruing interest for the pension fund as a whole right now?
Not for the pension fund. It was frozen, and the plan gets the value of the interest, and they get the value of the pension benefits, the annuities that he should have gotten that he gave up in order to continue on.
Yeah. That was what I was trying to inarticulately ask.
And then it goes on, still in the ordinance, after normal retirement date may be rehired by the village. Mr. Benton is not being rehired. He's continuing on with his employment. So there's no way that this ordinance is going to affect what occurred to him. So that takes care of that issue, I believe. With regard to Mr. Zelkowitz, I've already spoken of why we retained Mr. Burke to do the plan. He was the one individual who had the expertise and the experience and the confidence that he could get it resolved for us, and so we did so. Let's start at the beginning. In point number 1, this is a technical, or the village ordinance, both chapter 185 of the village ordinance both state the only person exempt from contributing to a police pension plan is the chief of police. It's actually a little bit different. He's got the option. He's not required, and he has the option to join in, and our chief has done so. He's opted to be in the plan. And so if we wanted to rehire him after his retirement, we've got to get the ordinance fixed, or he'll be in the same boat as everyone else was. Mr. Coop says membership shall be a mandatory condition of employment. Well, that contradicts a memo I received from the FOP lawyer dated December 8th, when he told me that this was the subject of negotiations. Can't have a mandatory condition and have it be negotiable at the same time. It's got to be one or the other. So he's misspeaking. Now, I think what he meant to say was the mandatory subject of bargaining. If it's a mandatory subject of bargaining, then the statute itself does not trump the constitutional right to bargain, which is Article 1, Section 6 of the Florida Constitution. So somewhere along the line here, we're going to have to address that issue, who trumps who. He says a copy of this letter in the ordinance should be sent to the division, we're talking about the actuary's report, should be sent to the division of retirement before the final public hearing of the ordinance. That is correct. In the chapter 185, there's a provision that says, and let me find it. A retirement plan or amendment to a retirement plan may not be proposed for adoption unless the proposed plan or amendment contains an actuarial estimate of the cost involved. We've done that. The actuary said it has no cost impact at all, zero. Such proposed plan or proposed plan change may not be adopted without the approval of the municipality. That's what we're trying to do here tonight, second reading. Copies of the proposed plan, this is a key word, copies, or proposed plan change and the actuarial impact statement of the proposed plan shall be furnished to the division before the last public hearing on the proposal is held. It's very common. This is keep us informed so we can make a judgment on the plan. We've got two objectives here. Well, we have one primary objective, and that is to get the qualification of the plan protected from the IRS. Any issues that the Division of Retirement may have with this is secondary to this first objective of satisfying IRS. There's no provision for any enforcement in the statute. And under the APA that I was describing to you earlier, if they're going to make this some type of requirement that has to be enforced, there's got to be a rule. There's got to be some type of an opportunity for us to have an input into the process. There's none in there. So I suggest that when we give this, we haven't already done so, I don't know whether we've done so or not, but when we do, they'll have ample time to review it. And all they're going to be looking at is, are we approving the plan the way the IRS wants us to do so? So that should be easy to accomplish. All right, there was a dispute over whether you had the right issue of the ordinance. And I believe that the clerk had a clerical error, it was an oversight, and a big issue was made out of that. The ordinance that you had in first reading was the same as you got in second reading. the ordinance, and I checked the language of the ordinance against the IRS's language in their letters of October 12 and October 15, 2018. It's identical. So there's no dispute. The language is the same. This is exactly the language the IRS wants us to adopt. I believe that addresses all of the issues in the last message from Mr. Coop. Is there any questions about that, Mayor?
I'll open it up to questions now from council.
Let me say one more thing. I'm not finished. Understand, issues regarding whether there's a, well, let me find the, one of the speakers remarked about essentially what was raised at the December 4 meeting I had with the FOP, that the process, whatever the process was as they understood it, stifled promotions and prevented upward mobility to sergeant. That assumption is based on the belief that the purpose of the amendment is to continue the practice of rehiring after retirement. That's not at all what we're trying to do. The village, as I said, has no present intentions to rehire except for potentially the chief. And there's no officers or sergeants that they would be interested in or under contract. The only individual is the lieutenant. He's got nowhere else to go. He's precluded by our ordinance, which was approved by the Division of Retirement, for participating. If there were any negotiable issues, the time has not yet come for them. Because there are no individuals out there who are in this capacity that they could even make an argument for. Now, you don't just get into negotiations. The union has the right to negotiate over people in their bargaining unit. In order to be in a bargaining unit, you have to have a community of interest. You don't get a community of interest with permanent and full-time employees when you're hired on a contract on a temporary basis. You have no expectation of continued employment. So the first hurdle that would have to be crossed is whether or not they're in the bargaining unit. That'll have to be accomplished by the Public Employees Relations Commission. Right now, we have full-time officers and sergeants. That should be it, Mayor.
Okay, great.
Before Mr. Carson sits down, did you all have questions for him? Okay, we'll go first then, since I've already spoken.
Thank you, Mr. Mayor. I just want to, and I know you said it, but I want to make sure it's clear for everybody here. The question I kept hearing from the public is, why are we doing this? And as I understand it, and as I understood it on first reading, the reason we're doing this is to save the qualification of the plan, correct?
That's absolutely correct.
Any other reason?
No.
Secondly,
well, protect the employees who would otherwise have to give back.
Actually, I'm getting that. That's my second question. The other question was some dispute as to who's impacted by this. If the plan qualification is lost, that's going to impact everybody in the plan.
Everybody, not just the individuals who.
Everybody.
Everybody. Exactly right.
Those are the 2 points I wanted to make sure were clear.
And actually, just to sort of double down on that, the language that we have provided to fix the plan, that council has provided, is the language that the IRS has given us as the approved language to fix the plan.
I verified that again today. It's the exact language the IRS has directed. Correct.
Councilman,
Thank you. So, Mr. Carter, I remember at first reading, Mr. Carter got up and had some questions about Chapter 112, I think it was. And I pledged to him that I would discuss those with you, and you have researched those and responded to those questions that he had.
Yes. All of Chapter 112.60, I watched the video of his presentation, and I believe that he recited 112.60. The chapter is called Actuarial Soundness of Retirement Systems. It's not directly related to what we're talking about, except to the extent that the actuary has already said there's no impact from this amendment.
Thank you. And just my final question to you is, as legal counsel to the village council, is it your recommendation to us tonight to adopt this ordinance?
Absolutely. If there are any other issues that remain to be seen, they can be dealt with. They're premature now. They can be dealt with at the appropriate time. And it's important to satisfy the IRS. That's the real problem right now. Anything else is an imagined problem that hasn't yet raised its head.
Thank you. That's all, Mr. Brown.
Councilman, any questions?
Mr. Carson, the question that I had asked you is the question about other cities, because it does seem that people are distrustful that we are not alone in this situation compared with other cities entering the voluntary correction program provided for by the IRS to fix problems such as the one that we have, a retroactive problem, not attending to Chapter 185, which we have been to several meetings, and we have a pension board that has heard this, and we referred to Mr. Levinson, who is the attorney. But it is true that Mr. Levinson did not advise us against adopting an ordinance that it is with the IRS's own voluntary correction program that we've entered into, spent the money in order to devise, and have been advised to go forward with. Is that correct?
That's correct. I can't give you a number of other municipalities who are involved, but there are numerous cities facing the same problems. We're not alone in this. In fact, that was one of the reasons why when we first tried to retain counsel to solve the problem, they were shying away from us. Oh, it's terrible. You're dead. We found a way to solve it.
Mr. Carson, have we been provided through your conversations with the FOP any contrary sort of financial actuarial information that suggests that in fact this is going to undermine it, other than the report that we commissioned? Have we heard anything else from them, officially, unofficially,
like that.
Something that says this is how it happens?
I'm not aware of anything contradicting the no impact statement.
Council, any other questions or comments? Mr. Mayor? Yes.
Thank you for all your information, Mr. Carson. Let me understand this a little bit deeper. What we're being asked to do and approve is equally applied to both the police pension and the general employees pension funds?
That's correct.
So there's nothing we're being asked to do only towards the police, which isn't being done to the general employees?
No, sir, because the employees in both groups were affected. So we're solving both problems.
So I see and I hear and I understand the police unions very vocal on behalf of their members fighting hard for what they believe are their rights. Has the general employees pension been heard or reached out or submitted letters or anything to bring up or maybe support some of the police union points?
I have not heard anything of that regard.
Okay. So backtracking, when you told everybody here that the plan's in jeopardy will be greatly affected, what does that mean in regular people language?
Well, the plan is gone if you don't have a qualified
But
plan.
will all those people lose their money if we don't do this?
Well, I spoke to the tax lawyer earlier today about this, trying to find out what could happen. And one of the things he remarked about was that all of the money which had been received could be penalized heavily, and it would affect also current members who are not even retired. It would take the current value of all of the funds that you had and assess you a penalty on it, and the plan would be gone.
Okay.
Now he did say that it's a harsh result, but if you thumb your nose at them, you're likely to see that, and that's why it's important to meet their compliance date.
So let me interrupt. I'm just trying to understand this like a regular person. You guys talk like lawyers. How does this affect, say one of the guys who works on one of the trucks in my neighborhood? How does this affect him if the plan is jeopardized? So he's being taxed now at what, like almost 30% on his pension, which he wouldn't be if we approve this? I mean, I don't understand.
Is he currently employed, or is he someone who's retired?
Let's put both scenarios.
Okay.
Guy retired recently.
If he's retired,
He has a small, modest pension, $9,000 a year or something from the village.
He's going to have to. These are funds which he never should have received because it wasn't a qualified plan. He's going to be paying penalties on it. That's my understanding from the.
What can we say? What 1% penalty?
I couldn't give you that number.
Okay.
I'd be reluctant to do so.
Or
it's severe, and the plan's gone.
Okay, and then people who work here now, the people who,
Don't have a retirement plan, and we have to figure out what to do about
unless
those.
we do this.
Well, this is a qualification defect. You fix the qualification defect by adopting the ordinance.
Okay.
Any other comment or questions, council? So, I had one more question. This was, sort of the last, and I don't think this was covered by your narrative earlier. One of the things that is alleged in Officer Coop's letter is that the proposed ordinance does not specify any benefits that this person should or will receive. But I read the plain language of the ordinance to say that they shall receive no new benefits. Isn't
No,
it?
they receive no new benefits. It justifies what they've already done.
Yeah.
They're not getting anything additional.
Okay, it says a rehired member may be eligible for a second retirement pension. That's by the plain language of the ordinance, not correct. Is that correct?
Say that again?
A rehired member may be eligible for a second retirement pension.
All this is doing, first of all, we have no more rehired members except for that one.
Right.
So all we're doing is we're saying to those individuals who have received money, you're okay. We wish we had the language back then when you got the money, but we're putting it in now with the IRS's blessing to protect you. That's what it's saying. Now, nobody is getting any additional funds from it, if I understand your question.
I mean, the language of
It has to be written that way in order to...
says, however, such member shall accrue no additional benefits under the plan. I mean, that seems pretty cut and dry.
That was in the general employees.
Oh, that was in the general employees.
Right.
I see that in both.
I understand your question now. What that's saying is, you retire. With this language, you're able to get an in-service distribution if you get rehired, but you're not going to go back and get any additional pension benefits. What you've earned, and the B paragraph tells you that you are 100% vested upon reaching normal retirement.
Yeah, and that's what I was looking for.
Right, and one of the suggestions was, well, we just start them all over again, and the IRS says no. You can't do that. If you bring someone back, they're going to continue to grow what they've got, and so they would be detrimental to the plan, actually, under those circumstances. And that was one of the suggestions that FOP made, and the IRS says no.
Yes.
I just have a comment that, as a person who's an employer in business, occasionally you run into situations where the IRS becomes involved and makes demands. And over a period of decades of working with this sort of thing, whether it's payroll or when those decisions come down, customarily the employer feels the benefit of cooperating with what the IRS decree is. And I just think if we're trying to bring this down to brass tacks and what the general public will understand is that compliance becomes very important in this case. And we've heard many examples of that. And the other thing I'd like to mention is that since most of the pushback about the ordinance has come from the police side, I'm the chairman of the police pension board. I sit on that board with Councilman Meltz and two very hardworking police trustees that were assigned by the FOP to be in that position, and they are Chris McDonald and Sam Mauda. Both of them have gone to the recommended trainings as pension board representatives. They've worked hard to understand and come quarterly and attend regularly the quarterly meetings that we have. We look very carefully at the very expensive, in my view, as a layperson, costs to carrying on with the pension. And they study it carefully. We do. We care a lot about the police pension. We care a lot about each and every individual officer. We sit there and look at those costs based on the individual officers that we're representing. And we appreciate our police department and what they do, day in and day out. And that's what we think about when we go to those meetings. And when we hear of a problem like this, we have to separate it. We have to separate it from what's going to happen in the future to address the questions and concerns that the department has with its own leadership and with the oversight that we have as council people. So I just wanted to explain that to you from a layman's standpoint. So I thank you for listening.
Thank you, Councilwoman. Further comments, questions? Council? All right.
Thank you for your attention.
Thank you very much. Why don't we go ahead and call the question then on this ordinance? Yep.
Do you need a motion?
Yeah, we probably need a motion.
Okay, I would like to move that we approve the ordinance on second reading.
I'll second it. Yes, just please. Okay. So we have a motion and a second. I'm going to call the question. All those in favor, please signify by saying aye. Aye. Opposed? Let's move on to 7B on second reading. And we'll open this one up for second reading, or for public hearing as well. If there's anybody that wishes to come up and speak on item 7B, come on up.
Did we, Mr. Mayor, I forget, did we read the title of the ordinance already? Okay, great, thank you.
So we're going to close the public hearing on that, and I think substantively a lot of the conversation is the same around this one as the last one. I don't know if anybody has any specific questions or comments on this. If not, I'll entertain a motion on this one.
I'd like to move that we approve the ordinance.
I'll second it. Okay, we have a motion and a second. I'll call the question. All those in favor, please signify by saying aye.
Aye.
Opposed? Okay.
Item 7.